Are there any other votes? Announce the results.
Ayes 86, noes 34.
The bill is passed. Mr. Morelli.
Yes, thank you, Mr. Speaker. I'm going to take advantage of the fact that Ms. Weinstein is prepared to do 3 bills of hers that are on the debate list. If I can give them to you in the order I'd like them taken up. The first is calendar number 453 on page 30. The next is calendar number 471 on page 32. And then concluding this grouping, calendar number 542 on page 39 of the main calendar.
Clerk will read.
Assembly 247, calendar 453, Ms. Weinstein, an act to amend the Real Property Actions and Proceedings Law.
An explanation is requested. Ms. Weinstein.
Okay. I thought we were going to do something else first. Okay. Very simply, this bill would allow defendant, the homeowner, to allege a lack of standing on behalf of the plaintiff, the lender, in a foreclosure action at any time during the proceeding, so that it would eliminate the current law that would record it. Well, it wouldn't eliminate it. Would supersede in certain cases the current law that says if you don't allege a lack of standing in the very early portion of the foreclosure proceeding, that it is waived.
Mr. McGevitt.
Will the sponsor yield for a few questions, please?
Will you yield, Ms. Weinstein?
Yes.
Ms. Weinstein yields.
Just to clarify so everyone understands, when we talk about attorneys in action, the plaintiff, the bank, will go and file a foreclosure action. It's up to the defendant to send a response that we call the answer. And many times they'll put defenses in the answer. A very common one is lack of personal jurisdiction, which is a fancy way of saying we don't think it was served properly. You didn't go and serve me personally or do the nail and mail or do it to another person. So that's a very common defense that's sometimes raised. Sometimes another defense that's raised is lack of standing by saying the plaintiff is not the right person bringing the lawsuit. And I know many times you and I have sat through hearings whereby you had one party, which a bank, which thought it owned the paper to bring the action, but sometimes they didn't, because sometimes the paper is transferred so many times and there isn't always a great record kept of the county clerk. So I guess the purpose behind your bill is to protect those defendants of saying, for lack of standing, on this day, ABC Bank appears to be the right plaintiff, but maybe it was Bank X, and they may not know that later on down the line. Is that really the purpose behind the bill you have here?
Yes, and especially in this age of sort of robo-signing relating to the sale of mortgages and mortgages being transferred in secondary mortgages, we want to make sure that the person, the plaintiff, the lender, the servicer that's bringing the action against the homeowner for foreclosure is the right entity. They own they own the mortgage. They are the correct party to bring that foreclosure action. And so often, because the homeowner, the defendant in this case, appears pro se without a lawyer during their first times when they get the initial paperwork, by the time they even know what's happening and can consult with a lawyer, sometimes their opportunity to object to it not being the correct party, that time period will have expired.
I understand the purpose behind it, but I think maybe a downside to this is that in New York, we have a very long and prolonged foreclosure process, but this could actually even prolong it even more, whereby the parties would go through the litigation, they have the mandatory settlement conference, and then very, very late in the process, when you think all these issues have been resolved, now very late, the defendant can now say, oh, there's now lack of standing, and really, to me, throw a much more complex part of the procedure and delays even further. So one of our purposes is hopefully to get these homes sold on to new owners and new purchasers who are going to go and put money in the house and rehabilitate it. By going and allowing them to do this at any time almost could really go and prolong the process. That's just a very big concern that I and others have with this bill.
Well, I understand what you're saying. First of all, in terms of the delay of a lot of the delays in the process, and we may talk about it later in one of the other bills, often those are actually generated by the lenders and not coming forward with proper information. But the reason why it may take some time before the homeowner actually can discover who the rightful owner of, who should be the rightful party to bring the action. And I don't think anyone wants a homeowner to be thrown out of their home by someone who isn't even entitled to be bringing that action. So often it would be after, once the settlement conference has begun, when the homeowner appears without counsel, eventually finds an attorney, tries to look at the paperwork, and somewhere along that time frame is when they may discover who whether it's the wrong party, and at that time they would be able to allege the defense of standing. So we would hope that once they determine that, they'd be able to bring that action, and hopefully it wouldn't be at the end of a process, but earlier in the process. But it would be whenever they were able to determine that it was the wrong party suing them.
If I could just direct on the page of the bill, lines 10 through 13, are the issues which I have the biggest concern with. And what it says is that the defendant may bring this action even after the responsive pleading is done, after the pre-answer motion to dismiss is done. So you're giving that defendant some additional time. But then lines 10 through 13 say the following. A defendant may not raise an objection to defense of lack of standing following a foreclosure sale. Now, that part I agree wholeheartedly with, because once foreclosure sales occurred, many times the bank winds up buying back the property anyway, and there hopefully come a time where they'll start off to a new person who will either flip the house or rebuild the house and move it on. So that, I think, is a very good section. The next two lines is the one I'm struggling the most with, which says, however, unless the judgment or foreclosure and sale was issued upon defendant's default. Could you just explain those two lines of the bill?
Right. Well, you do read it correctly, obviously. The only time that the action can be brought after the sale is when the property is foreclosed and the judgment of sale is entered without the defendant ever having made an appearance. And often that is because they did not receive proper notice of the foreclosure action. They didn't go to court, and they were never in a position to be able to object during the proceeding.
My concern with it, though, is follows. You could have a situation whereby, for whatever reason, the defendant defaulted on the property. The bank buys back the mortgage at that point, and then in some instance, they will go and they will sell it to another party. And you may have a situation whereby a new person has bought the house, has put substantial sums of money into it, and now at that point, this whole concept of lack of standing is brought up. And the reason why I saw this, we just very recently received a memo from the New York State Land Title Association, and their perspective is that they may have a problem insuring title in the future if now there's no time limit as to when that occurs. So you could have a situation of 1, 2, 3 years go by where, again, a new person's owned the house, and then out of nowhere, comes the defendant who defaulted on the property, and now they're going to say, okay, we're going to litigate this issue, but now what happens to that new person in the house? They bought it, they put $100,000 in the house, they're selling there, raising the family. What happens to them then if this lack of defense of standing can be made at that point? Again, maybe I'm just reading it wrong, maybe they're reading it wrong, but just the way I'm reading that just is a concern.
No, I understand what you're saying, but I think it's a little bit unrealistic to think that someone has purchased a house, spent months doing renovation, moved in, and that's the first time that someone, that the homeowner would realize what's happened with the property. I mean, obviously, we're not looking to have a cloud of ownership on the property. We actually, in terms of the Land Title Association, had made some changes along the way to accommodate some of their issues. Actually, it had been my understanding they weren't objecting. They had withdrawn their opposition on the bill because of some of the changes we made. I would just say that you don't want someone to lose their home to a party that was not entitled to take it from them.
I understand. Again, looking at literally what's there on lines 10 to 11, I think that's an outstanding part of the bill because you want to make sure that, again, just the way, and again, maybe we could just be a disagreement reading it, but I just think there could be some clarification there or just even some sort of time limit there because you say, yes, it may be unrealistic that it would be some time down the line that this person could come out of the blue. And I agree with you. I think it's highly unlikely that would occur, but just in those instances, I think there should just perhaps be some sort of end time, or if simply it said they may not raise the objection following the foreclosure sale, and it would be a period there, then I'd be completely agreeing with the bill. I think that would be a very, very good bill. Just to me, those additional lines just add some uncertainty, which just makes me feel uncomfortable with it.
The response would be just because of some of the sewer service that does take place, to have someone lose their home when they were never on a default, where they never received the notification, there is a pretty severe penalty for them. So, we certainly can, as we move forward, could look at your suggestion. As I said, we did meet with the land title folks. We can look at those issues again, but I do think that we have come down on the right side on this.
Thank you. Mr. Speaker, on the bill.
On the bill, Mr. McKevitt.
Certainly, I agree that certainly when you had the robo-signing instances with the banks and you had the situations going back and forth, it was difficult to figure out who does own that mortgage. Again, because the banks go and they transfer them so quickly is a problem. Again, I've sat through hearings with the sponsor whereby that was an issue whereby even the own bank couldn't determine who owned the proper paperwork in order for it to occur. So certainly I do agree that there may be instances where you can give that homeowner an additional time to make that defense, because at the time of the pleading, they wouldn't know it. They think the ABC Bank owned it. ABC Bank may have thought they indeed owned it when actually another bank had made it in the transfer title. My question is that after a foreclosure sale, to me, there should be some sort of finality. And again, I agree, it's probably very, very rare that you would have another party coming out after the home has been transferred, but the possibility exists that after the bank has bought back the mortgage at the foreclosure sale, sold it on to a new homeowner may have now comfortably built the house, made it to a good house, and I think that's what we want. We have this problem, we have all these homes around the state, they're laying vacant and abandoned. We want someone new to buy the house. We want them to buy it, make it look good, respectable, and that goes and brings the value up of all the houses in the neighborhood. But if there's now going to be a concern that a person who defaulted on it can come back at some time later and be able to go and throw that defense when a new person owns the house, I think that would be actually quite detrimental. So, again, I agree with the sponsor. Maybe we could work on some sort of language, making sure after the sale that this defense can't be raised, or maybe some sort of time limit to give the housing market and those new owners some sort of comfort. But until then, I'm going to go and vote against the bill and recommend my colleagues do the same. Thank you.
Thank you. Read the last section.
This act shall take effect immediately.
Clerk will record the vote. Mr. Kearns to explain his vote.
Thank you, Mr. Speaker. I want to commend the sponsor of this bill. In Western New York, we have thousands of zombie properties, and I know there's going to be future bills where we can go in and discuss this further. But this is a good bill. We need to hold the banks accountable and responsible of what they've done for our communities. I do not see any problem with this bill. I'm sick and tired of the banks saying that they do not have enough time, that we have one of the longest foreclosure processes in the country. Time and time again in my community, they either walk away from properties, they hold on to properties for 6, 7, 8, or 9 years. When it's in their best interest, they do what they want to do and they expedite the process. With that, I vote in the affirmative. Thank you, Mr. Speaker.
Mr. Kearns in the affirmative. Ms. Corwin.
Thank you, Mr. Speaker. To explain my vote, my colleague's right. We do have hundreds, if not thousands, of properties in Western New York that are zombie properties that have been in foreclosure process and are sitting idle and vacant. We were just out there recently at one in my own district. It was very unkempt. It was falling into disrepair, and the neighbors were very concerned about that. But that is why I'm voting against this bill, because my concern here is if homeowners who are interested in purchasing a property that had been foreclosed on believe that there can be some sort of court action taken to prevent them from having that house, or they have the house, they spend money on it, and now they're in litigation because of this lack of standing, I'm afraid that people will be not interested in purchasing homes that are coming out of foreclosure. So for that reason, I will be voting no against this bill, and I encourage everyone else to do the same.
Ms. Corwin in the negative. wait your turn. Tell them I said, wait your turn. Are there any other votes? Announce the results.
Ayes 77, noes 32.
The bill is passed. Mr. Morelli.
Yes, thank you, Mr. Speaker, for allowing a brief interruption so that I might make several introductions of visitors and guests who have joined us. First of all, on behalf of the Speaker, we are delighted to have the Portuguese Consul General, Manuel Bairos, is here. She has spent a career in the diplomatic corps, a number of places around the United States and around the world. We are delighted. It is important to note that Portugal was the second nation to recognize a young United States of America. They've been longtime friends, and there has been a consulate office in the United States for 225 years in New York, and we are delighted to have Ms. Bairos in the chambers as our guest, and we would certainly ask you to extend all the cordialities of the House on behalf of the Speaker and the members, sir.
Certainly, on behalf of the Speaker and all the members, Consul General, we are so pleased to have you here with us today. We extend to you the privileges of the floor. As you may know, this is the People's House, and so appropriate that with that long history you have with the United States, that you're here to visit us. Thank you, and I hope this day is good for you. Thank you. Mr. Morelli.
Yes, thank you, sir. Let me also, on behalf of Mr. Sepulveda, introduce a number of guests who have joined us as well from the Bronx Manhattan North Association of Realtors who are in town today to observe our proceedings. We are joined by Miriam Toro, who is a board member, Christina Stevens, who is the president-elect of the organization, as well as Eleazar, who is the CEO, Eleazar Rodriguez, who is the CEO of the Bronx Manhattan North Association of Realtors. We're delighted to have them today. I'm sure that they're participating in the Bronx Day, and I know everyone is anxious to participate in those festivities. We're delighted they took some time out of their schedule to join us as guests of Mr. Sepulveda and the members of the Bronx.
Certainly, on behalf of Mr. Sepulveda, the Speaker, all the members of the Bronx delegation, and all of the members, we welcome you here to the New York State Assembly. We extend to you the privileges of the floor. Congratulations for your president-elect and the officers of the organization. We are always happy to have you, and hopefully we'll see you later today when the situation will be a little bit lighter. Thank you so very much.